Defense.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. When I first spoke to you about this, I asked you a fairly simple question. What would you do? What would you do if you were faced with a situation in which you believed that your life, or the life of someone else that you cared about, was in danger? And here we found what Mr. Michael Dixon would do. And that's that he would defend himself when he felt that he was in danger. When his life was threatened, when he was told that someone was going to kill him repeatedly, someone who had pulled weapons on him before, who others had said he'd pulled weapons on before, and who said, "I'm going to kill you." So Mr. Dixon found a weapon to protect himself. And when once again he was told, "I'm going to kill you," and he heard the safety release, that's when he finally made the ultimate decision to protect himself. Now, why do we know this? It's fairly simple why we know this, and it's because he told us. He told us. He told law enforcement. He's told everybody exactly what happened. And you don't have to take my word for it. The lead detective on the stand said, we didn't believe him at first, but then he gave us another piece of the puzzle. You heard the state literally just say, where do we get most of this evidence? His own admission. And don't you think it's rather convenient that they're going to take his word for it every single time it fits with their story? But when it doesn't fit with their story, all of a sudden now he's a liar. He's already admitted, I didn't tell you the truth at the beginning. He's already admitted, I didn't want to get in trouble. He's already told you, I didn't tell them what was going on because I wanted to protect myself and my daughter. And then when he was caught, and he admitted it, he didn't just tell them he killed him. He walked the entire property and showed him bit by bit, moment by moment, what happened. And they said, this scene here doesn't make sense. Well, of course. So what did he do? He rearranged the room back to the way it was and said to them, here's why it doesn't make sense. Now does it make more sense? They called him a liar, pulled out a tape measure and said, there's no way that this refrigerator could fit here. He said, I guarantee it does. Blood spatters on the ceiling. And lo and behold, they moved the refrigerator back, and there it is. A perfect fit, exactly where it was. And why do we know where it was? Because he told us. As we're going through this, I want you to keep in mind that every time the state calls him a liar, they're not actually calling him a liar. They're calling him a liar when it's convenient for their story. They are happy to accept his truth when it fits with what they're charging him with. It's when he claims self-defense as what actually happened that they call him a liar. Does that make sense? Does it make sense to only believe a person when it's convenient for you? So as the state did, I'm similarly going to go over these charges, go over some of the testimony, and give you sort of a roadmap as you begin your deliberations. because the state did give you some of the testimony and recite some of it, but conveniently left some things out. When talking about the testimony of his daughter, Julie, she was proud to talk about how her dad taught her how to shoot. When speaking about a gun, said specifically, quote, he knew what to do with it. He knew what to do with it. He knew how to shoot a gun. That adds a little something, right? If you have a person who knows how to use a gun and is saying, I'm going to kill you, and then raises a gun to you, that's a little different than just some random person. We heard from Edwin Jester, who said that everybody had arguments with Jimmy. This wasn't unusual. This wasn't an unusual circumstance. The state glosses over that part. The state glosses over the part where the witnesses talked about Mr. Whitaker pulling guns on them. John Dixon, Michael's brother, talks about how Mr. Whitaker pulled a gun on him and how Michael had to stand in between them. Michael had to protect him from Mr. Whitaker, who had pulled a gun on him. The state is very quick to talk about how Mr. Dixon was using meth, how he's not believable, but glosses over the fact that Keith Strickland is also a meth user. In fact, has said he's used meth for a decade plus, but he's to be believed. Why? Because it fits their story. The state talked about the detectives who came to the house and how Mr. Dixon changed the story over and over again and acted like this was a long-standing lie, like this happened for days on end. The truth is, this all happened in a compressed amount of time. He was first approached by law enforcement on the 25th of July about gunshots at the house. At no point was Mr. Dixon asked about the disappearance. Mr. McKnight, the officer, said, we didn't even go there on any missing person. We were just asking about gunshots. Nothing out of the ordinary. Didn't even warrant any further investigation. Then, the next time Mr. Dixon meets up with law enforcement, it's on the 27th. That's when he's arrested. So all of these stories that they act like he led these police on wild goose chase, it happened over hours. This isn't on weeks. This isn't months. From the time he was arrested and initially denied it, which as every officer on the stand admitted, people accused of things often don't come clean, within hours he was already admitting to officers that he did it. Then he goes on a walkthrough and leads them through step by step. Did the story change? Somewhat. There are parts that changed. But the primary issues were, A, he admitted that he killed him, and B, said it was in self-defense. When you go back there, you're going to be looking at a variety of charges. Mr. Dixon is charged with 13 counts. And I told you at the beginning, some of these are going to be easier than others. And the reason is, again, Mr. Dixon has admitted some of these. Now, at this point, I think it's important to remember, I'm not asking you to like Mr. Dixon. I'm not asking you to understand all of his conduct. I'm not asking for you to forgive him for any of his conduct. And I am fully with you that some of these acts that he committed are heinous. He admits they are heinous. And I asked you at the beginning, to not let that prevent you from going through each of the charges step by step to say, did he do this? Each element of these charges. And I recognize that'll be difficult. You have a person who sat on the stand and told you that he burned a human body. That is unequivocally awful. And I'm not going to pretend it's not. I'm not going to ask you to somehow get into the mind of why someone would do that. What I'm asking you to do is that after you deal with that particular charge, which remember, there's a charge for abuse of a corpse and tampering with evidence. Once you are done evaluating those two things, you then move to the other charge. Burning a body is not murder, unless, of course, they're alive, which in this case, it's quite clear he wasn't. So the state is trying to convolute a lot of these charges together, and they're trying to ask you to evaluate the entirety of it in one fell swoop, and you cannot do that. You have to go charge by charge. So tampering with evidence on count 4, producing cranial fractures or fractures of the jaw. You heard from an anthropologist, and they said specifically that the cranial fractures were from blunt force trauma. When asked specifically, could a gunshot have done that? The answer was yes. Now, you've already heard Mr. Dixon admit to shooting him. So can you say that if you have an anthropologist sit up there and say that, yeah, a gunshot could have caused that? An expert in her field? Are you going to substitute your judgment and say it couldn't have been that? Bear in mind, it's the state's obligation to prove beyond a reasonable doubt that that's not what happened for that particular charge. Just by bringing a hammer into a courtroom doesn't mean that's what happened. They keep saying that he's admitted to smashing his jaw and smashing his teeth. When asked about it, the detective said he did not say that. He admitted on the stand. Mr. Dixon never told him that. He heard from another person who may have heard from Mr. Dixon. And on and on and on. That's not an admission by Mr. Dixon. So again, when you're asked to evaluate, did he tamper with evidence? Well, if you believe that he shot him, which everyone seems to be assuming because, again, he admitted that, then you have to evaluate that from the perspective of a person was shot with a large round, which everyone, including the officer who said that he carries that because it's a large round, that could not have done that. That could not have produced the fractures. You don't need to substitute your judgment for an expert in the field, an anthropologist, who said that she couldn't even rule it out. If an expert cannot rule it out, that is a reasonable doubt. Count 5, the breaking and cutting of bones. Again, an anthropologist came in and said that these bones were cut. Mr. Dixon went up there and said, I didn't do it, but admitted to all of you. He could see why anyone could say, if an expert's going to come in and say they were cut, I could see why someone else would think I did that. Take him at his word or not, he's saying he didn't cut them up. But even if you find that, again, you just have to find that he did so with the purpose of tampering. Count 6, place the body in a burn pit instead of Ablaze. Again, there's a reason we know this happened. It's because Mr. Dixon admitted to it. If you recall, the officer said on the stand, that's why we went there. It was after he told us we put a tarp out there. It's his admission that even allowed them to find all of that because they said there was expected to be heavy rains that night, which would have washed away the evidence. His admission is what led them there. They tried to cover it up, tried to say, well, we heard information about it otherwise. They weren't putting tarps out there on that property until he told them about it. That's the truth. That's the actual linear timeline. Count 7, to clean and rearrange the location where he was killed. Again, he admitted to this. And I find it fascinating that the state's saying, of course, find him guilty of that one. Find him guilty of the burn pit because he admitted to it. Just don't buy the other parts of the story. Only the ones that fit with our charges. Count 8, stealing, selling, or destroying a flat screen TV. You heard today why he got rid of it. I traded it for meth. Is that with the purpose of impeding an investigation? Or is that a meth addict trying to get some meth? That is an important part of this. Again, you don't have to find him guilty of this tampering just because you find him guilty of other tamperings. Each one is an individual count. And I think it's important for you to figure out, is that why he got rid of this TV? Or did he do what he just said he did, which was, I was trying to get some meth, so I sold a TV. It's instructive that when you look in that house, it's not like he gutted the entire house, getting every single valuable out of there. Aside from the fact it was a hoarder house to begin with, it's not like he ransacked the entire house. So does it make sense that he got rid of the TV because it was one of the few things of value that he could trade for meth? Yeah, that makes sense. If that's a reasonable explanation, that's reasonable doubt as to that count. Count 9. Tampering involving a suicide note. You're going to be getting a copy of that note. You're also going to be getting a copy of the statement that Mr. Dixon produced. And you can look and see that the handwriting doesn't look even close to similar. You heard on the stand today that it was Melody Dixon who produced this note to somebody else. So if Mr. Dixon had nothing to do with writing the note, if his handwriting looks nothing like it, if he didn't even give the note to anybody, it was somebody else, how can he then be guilty of this one count of tampering? Again, you need to go through each one of these counts to make sure that it's actually him. You can't just say, well, if he tampered once, he tampered in all of them. They're each individual counts, individual charges. And he may have done some of them and not others. And that's something you need to look at. Count 11, again, gross abuse of a corpse. Mr. Dixon's already told you what he did. Count 12, sexual battery. On this count, ladies and gentlemen, there's literally no evidence. None. This count requires a finding that Mr. Dixon engaged in sexual conduct. Sexual conduct is very specific. It is a sexual act that involves penetration of some kind or oral sex. You have heard nothing to indicate that happened. You heard that he stayed in the basement, of which you've seen pictures, of which you've heard testimony from Officer Robinson that there was at least 2 bedrooms. You heard evidence today that there was 3 bedrooms. And you heard evidence from a meth head who said that after using meth with them, he heard movement. Specifically, did not hear any sounds from Mr. Dixon. Specifically, did not hear any sounds from Melody Dixon. He heard movement. How you can get from heard movement downstairs to I heard penetrating sexual activity is quite a leap. And to say you can get there beyond a reasonable doubt, I find that unbelievable. He admitted he never followed them down there, admitted he didn't even see where they both slept, said I never followed them down, never saw where they were slept, didn't even go down to the basement to see where they were. Did nothing of the sort. One person said this. That's it. On that count, ladies and gentlemen, I don't even see how you could possibly find Mr. Dixon guilty of that count. Count 13, engaging a pattern of corrupt activity. Ladies and gentlemen, this is going to hinge on whether an enterprise was committed or an enterprise was created. Mr. Dixon has told you from the beginning he did everything. All of that stuff was him. Said Melody had nothing to do with it. Said after Mr. Whitaker was shot, he sent her to the basement, took care of everything on his own. This is the kind of charge that's reserved for, as the state mentioned, gangs, for the mob. It's not what we have here. We have a person who killed somebody, freaked out, made horrible decisions, and tried to hide it. That's what happened. This is not some grand scheme amongst a bunch of people. This is not something involving a whole bunch of people. This isn't involving anybody else. It's just Mr. Dixon. He's admitted that here. He's told you all he did it. He told law enforcement he did it. But again, it's another case. The state wants you to believe part of what he says, but only up to a point. And then finally we have the murder charge and the felony murder charge. Ladies and gentlemen, there were 3 people there that night. And 2 of them are alive and 1 of them is dead. Now, we know that Mr. Dixon killed James Whitaker. And the reason we know that is because he's told us all. Again, he told us he shot him. But the question is, what led to that? And this is why I told you all, while the state's going to ask you to consider all the rest of this as if it was part of the killing, it's not. It's just simply not. All of that other stuff, all of the alleged tampering or the actual tampering that took place, all of the stuff that happened after the fact is just that, after the fact. That doesn't say whether there was a murder or whether it was in self-defense. All of that is that 60 seconds when they walked through the door. And you heard from Mr. Dixon what happened. You heard that he walked home, into the home he was at. Don't forget, the state continues to tell you that this was Mr. Whitaker's home, this is Mr. Whitaker's home, his castle. This was Mr. Dixon's home. He'd lived there for 2 years. Just because he wasn't on the deed doesn't make it not his residence. And then he was told to leave at gunpoint while his daughter was in the home. Does that sound like a decision that one could make or should have to make? You leave and leave your daughter here with somebody who has a gun who has threatened your life just now. Does that sound like a reasonable choice to make? No, that's not an actual choice. That's not an actual choice to retreat or responsibility to retreat, because no one would leave their daughter in a situation with a person who seems unhinged and has a gun on them and is threatening to kill people. That's not a reasonable decision. It's not a reasonable choice to make. The reasonable choice is to go get your own firearm to defend yourself and whomever else you need to. That's the reasonable choice to make. And so when you're asked to look at self-defense, you're going to ask, who created the situation? Well, if you have a person who is threatening you with a gun, that person created the situation. Again, did the defendant have reasonable grounds to believe, or an honest belief, that they were in danger of serious harm or death? Well, again, person with a gun who's pulled a gun on him and others threatens his life. That seems like an honest belief that you're in danger. The defendant's violated a duty to retreat. Again, we've already gone over that. The request to retreat was retreat while you leave your daughter in harm's way. Not really a reasonable decision to have to make. And finally, the defendant did not use reasonable force. Well, if someone is coming at you with a gun and threatening to kill you, you have the right to defend yourself. I think that's pretty well established. We need to address some of the things that the state said in their close that is either simply inaccurate or slanted inappropriately. They talked about blood that was in the gun and said there was human blood in the gun. That's not what was testified to. There was blood in the gun, but she specifically said on the stand, because I wanted to make sure I asked her this question. I thought it was very important. Was that human blood? And her response was, I don't know. She said there was human DNA in the barrel of the gun. She didn't know where that came from, and that there was blood of some kind. Didn't know if it was animal blood, didn't know if it was human blood, didn't even test it for that. That is an important distinction, because if you just assume it's human blood, that can lead you to a whole set of other conclusions. But it wasn't. She has no idea what kind of blood it was. It was just some blood and some human DNA that she couldn't verify because there wasn't even enough in there to figure out whose it might have been. So literally, we have no idea what was inside the barrel of the gun. There was some stuff, and that's about as far as it gets. They talked about this sled, and he showed a picture of Mr. Dixon being thin and Mr. Whitaker being less thin, and indicated somehow that this implied he was unable to drag him out of the house. A deer sled is used to drag things that are heavier elsewhere. That is the purpose of it. The purpose of a deer sled is if you shoot the deer, you don't have to drag it back on your shoulder. You put it on the deer sled and you drag it. And this is a perfect corollary for what happened. Again, I recognize I am talking about not a deer but a person here, and that may offend the sensibilities, and it probably should. But don't let that distract you from the actual facts. Don't let that distract you from the fact that, yes, this could have happened. This didn't happen in 5 minutes. It happened over an hour. That he already admitted. He rearranged stuff within the house. Because this happened a month prior to the officers being there in those videos. 3 weeks, 4 weeks, whatever the amount of time is, it was certainly enough to move things around. So let's not act like it was impossible, some impossible act or feat of strength. It was simply what he did. And we know that because he admitted it. The state told you that they don't have to prove motive, and that is true. They don't have to prove motive. But it's also true that you're allowed to consider motive. And this is one thing that hasn't come up during this case really at all, which I find fascinating. Why? Why would he do this? You're allowed to ask that question. You're allowed to wonder, because it's important. Why? He was living with this guy for 2 years, said he considered him uncle. In that confession video with former Detective Downs, he asks him, "Are you sad?" And when he says yes, and he's asked why, he doesn't say, "I'm sad for myself." He doesn't say, "I know I'm in trouble." He said, "I'm sad for him because he's not here anymore. Because I can't get him back." Today on the stand, he said, "I thought of him as an uncle. And I can't bring him back." That's not unimportant. That's not throwaway dialogue. That goes to why. Why would this happen? He's living in the house with this guy for 2 years. The state would somehow have you believe that he did this so he could then sell a couple of guns and a TV over a period of weeks? Does that make sense? It was testified to that Mr. Whitaker helped support him, gave him some money, helped him work, let him stay in the house, gave him food. Why would he kill that meal ticket? Why would he do that? Unless he was in a situation he felt like he had to. Doesn't that make more sense? Doesn't that seem Like the more reasonable thing? So they don't have to prove any sort of motive beyond a reasonable doubt, but they should have to prove to you some reason, give you some explanation for why he would do this, when the other explanation is reasonable. That he was in a situation where he felt that his life was in danger and he had to protect himself. That's a reasonable explanation. In fact, that has been the explanation since he admitted to doing this. That he felt his life was in danger. And bear in mind, I don't have to prove Mr. Dixon innocent. We went over this during voir dire, during opening. The burden here is on the state. And I'm not asking you to make them prove beyond any hypothetical doubt, any philosophical doubt, any imaginary doubt. I'm asking you to have them prove beyond a reasonable doubt. And if the question of self-defense is reasonable, and it is, then you have to get beyond that reasonable doubt. And that's the crux of this issue. That's the crux of that 60 seconds. Is that I don't have to prove he's innocent, and yet I've provided you with the most reasonable explanation. That he was in a situation where he felt his life was in danger, where he'd been threatened with death and with a loaded gun, to his belief, and that he heard the click of a safety going off, and so he shot to defend himself. That's the story he's been consistent about. That story, when he came at the end, what he told you here today, that is the full story. And the state will have you believe, well, he's told this story, that story, some progression, some evolution. When he got down to it, he admitted, here's all the things I did. And in the walkthrough, he gave the full story. And today, he gave you the full story. And another question of why that you should ask is, why would he give all these details freely? Because not what happened. It doesn't help him to admit to officers to having done all this. That doesn't help Mr. Dixon at all to do a walkthrough of the entire property and point out location by location, act by act. So what's the reasonable inference there? That's the truth. That's what happened. So ladies and gentlemen, this is going to be the last chance you're going to have to hear from me, or get to hear from me. And the state is going to have an opportunity to tell you why the things I'm saying to you should not be believed. What I want to leave you with is, again, this case involves whether the state has proven beyond a reasonable doubt each and every element of each and every charge. And so I'm asking you not to just look at Mr. Dixon and say, how could this person have done those horrible things he admitted to? I'm asking you to evaluate each and every charge individually, each element of every charge individually, and to say, I have no reasonable doubt about this, because that is the standard that you need to hold them to. And if I provided you a story, if Mr. Dixon has provided you a story, the same story he's provided to law enforcement that brought us all this evidence here today, all the pieces of the puzzle that he gave law enforcement that they've admitted they received, if any one of those things has given you a reasonable doubt, I'm going to ask you for a not guilty finding on those charges. And most pertinently, to the charge of murder, when he tells you he defended himself, when he says that's how far he would go to defend himself, I'm going to ask you to take him at his word on that and to find him not guilty. Thank you.
And I think we'll take a very short break before there's rebuttal. As I've told you before, do not discuss the case among yourselves. Do not permit anybody to discuss you or in your presence. It is your duty not to form or express any opinion on the case until it's finally submitted to you. We'll take about a 10-minute break, back about 5 after. Thank you.
Thank you.